guidance on our enforcement policies, our enforcement practices. And part of that, we are at the very beginning stage, guidance on our enforcement policies, our enforcement programs, and part of that, looking at what provisions they have, those that are similar, those that are a little different than ours, to make a full assessment of where we are in our process and what things, if any, that we need to address. Our last meeting, we got right into it with actually looking at what Chair Petit calls homework by investigating sister organizations and comparing and contrasting those information that was collected to what we have now. I look forward to continuing this committee. We have lots of work to do before us and lots of great things to evaluate. But unless you have questions directly for me, the committee itself is moving forward with continuing to gather information so we can one day perhaps have recommendations to bring to the full commission.
Thank you, Chief Johnson. And Commissioner Mitchell, did you have anything to add?
Not much. Just to update the rest of the commission. I specifically spoke with a couple of different ethics commissions, the ones in Los Angeles and San Diego, which were really interesting conversations about how they faced these challenges. Los Angeles in particular, they actually came together with an enforcement subcommittee a few years ago, dealing with some of the same kinds of questions that we had, and came to their own conclusions and set a couple of policies that we're looking at to kind of decide whether we want to go in the same direction as they did. And the commissions also were very interested in knowing what we come up with. So we have the opportunity to perhaps influence policy and procedures for other commissions as well in the state as we go through this. So it's a nice opportunity that we have here as we go forward.
Thank you, Commissioner Mitchell. Is there any public comment on this item? Recognizing Mr. Kantz, we'll give you 3 minutes.
Hi, good evening again. I just would suggest in the future you make these meetings open to the public. The public has contributions to make, and it's hard to understand what's going on if the meetings are basically private and there's no chance for public input or chance for the public to understand just what's occurring at these meetings. So in the era of Zoom, it's an easy thing to do. And I know when I was on the commission, we made every meeting of every committee, or everything we did was public. And we put notice out for it and invited public participation because it improves the ultimate product that comes out of the process. So I would encourage you to do that in the future. Thank you.
Thank you, Mr. Kantz. Any other public comment? All right, we will move on to item 7B. The Public Records Performance Committee is on hold for right now until we get a representative from our additional commissioner added from the city manager's office. So we are waiting for that to take place. All right, we'll move on to our informational items. First informational item, item number 8, is the Oakland Campaign Reform Act Guide 2022. So we will now hear from staff.
Good evening, commissioners and members of the community that are here tonight. This is Suzanne Dorn. I'm a lead analyst presenting on our Oakland Campaign Reform Act Guide for 2022. A copy of the guide was provided with your materials for your information. The guide was revised to include updated contribution and voluntary spending limits. There are some changes to reflect updates to our online filing processes and local forms, and some minor clarifying changes to the language throughout, but no changes have happened to the law in this meantime. They're mostly housekeeping changes. So this is an informational item so that staff could share the final draft with the commission members prior to publication. And I'm happy to take any comments or questions you have.
Open it up to the commissioners for any comments or questions for staff.
What have been the most common questions that arise that we're trying to preempt with some of the things that we have in this?
So yeah, as I mentioned, it was mostly around process changes. I'd say, maybe, actually I'm kind of guessing, I'm off the top of my head, but about maybe half of our assistance requests are technical. So having the process for electronic filing line up with the changes we made in 2020 was important to reduce confusion. And we also have provided now copies of the electronic versions of the forms that we went to in 2020 instead of hard paper copies that were used in the past. So that was there. And then the other one that was we thought was important was clarifying in the contractor ban section that lobbyists we name them explicitly as agents that could fall under the contractor ban for contributions if they had been advocating on behalf of a contractor. So those were the main things. Others were just like, say, formatting and things to make it easier to read, things like that.
Any other comments from the commissioners? I just want to say that in my brief review, I like the examples that are in there because that is always helpful. So people have like real life case examples they can look at when they're trying to understand certain things. And the fact that you've highlighted the tips, the candidate tips, that is something that, typically draws the eye of someone who just wants to look at something quickly. So thank you for doing that. Because, everybody doesn't want to read the entire dictionary when they're looking for one word. So it's helpful to have things highlighted like that. There are no more comments by the commissioners. We'll open it up to the public. Seeing none, we will move on to item number, thank you, Ms. Durant. We'll move on to item number 9, disclosure and engagement. And I think that's still you. Do you have anything to add to your report?
Just briefly, I wanted to update the commissioners on some activity we did on the ethics onboarding and exit process that that we've been working on. Since the agenda posting staff has met a couple more times with our citywide training manager. All 3 mandatory trainings we now have live on the citywide employee training platform. So departments will now have the ability to assign the training and track it, which has been a big thing for us. And in addition, it's now set up to for example, our training for Form 700 filers is mandatory every 2 years. So the system that is noted in the system, and people will automatically get that notification after 2 years that their time is up to take it again. So we're kind of taking it out of the realm of human error and tracking, and the system's going to be taking care of that going forward. In addition, we coordinated with HR so that notices should go out from all the departments to their 700 filers, reminding them of the deadline and of our mandatory training. And that was one of our goals. And they will be incorporating our checklist items on the administrative side of so NeoGov is like it's an online platform that city staff use to track the onboarding and offboarding process for employees. So our checklist items for assigning training and noting whether people are Form 700 filers, those are going to be incorporated into the system so that they're much more clear and they're all communicated as part of the process, so people cannot miss it when they're going through. And we're making sure that each person who's subject to these requirements is aware of it and that the requirements are communicated to them and tracked. So those are some big things that we've got done. And as those are implemented, we'll be checking back with HR and letting the commission know when those items are complete. And I think that's basically it.
Any comment from the commissioners or questions?
So the tracking for the for the ethics trainings. So historically, that's been done manually.
So it's two parts. So the first part was making it a mandatory item in the database, right, for all the personnel, that they must check whether they're a Form 700 filer or not. So that's like part one, and eventually that's going to lead to a complete list. Although we're also working on some shortcuts with IT to see if we can also do it by classification. But so that's part one. And then basically by doing that, then that also is going to set off that this person is required to do the training. And then the system tracks whether that they'll automatically be assigned the training, and the system will be noticing them and tracking whether they take it or not. And that will all be visible to PC staff as well. We'll be able to audit it. So yeah, I mean, in the past, it was just, I guess it was spotty. There wasn't there wasn't a way that they were being assigned it. Let's put it that way, so that it could be tracked. It was just sort of that they were told they need to do it, but there was no process set up where you had a list of people that you could check against and see if they did or did not do it.
Okay, great. So that's wonderful. So we'll be able to track going forward now, how many people need to take the training, and then out of that, how many people actually took it in a way that we weren't in the past?
Exactly.
Right.
Yes, it's going to be big. And this year is going to be a little, so this year will still be a little messy because it wasn't implemented before the beginning of the year. And we'll still have some people who may have done a live training or taken it on the old platform Target Solutions, and then some on NeoGov. But immediately at the end of April, after the onboarding cycle in April, we are going to be getting back together with HR to see, is it working so far? Are the people who just got onboarded, are they ticked off? Are they doing the training within 30 days? So we're going to check that. And then our plan is to do a joint training at you've heard the term SPOCs before, a single point of contact for the departments. Those are usually the people that are doing this. So we'll go to that citywide meeting for the SPOCs, and we're going to do a joint training for them on the process and answer any questions they have and make sure that everything's working the way it's supposed to be.
Great. So I look forward to seeing numbers on this stuff in future briefings.
Yes.
Great.
That's our goal. Yes.
Okay. Okay, cool. Also, I got the reminder to file my Form 700, I guess a month before the deadline. So that was nice to see.
Great. Oh, I guess one other thing I wanted to mention was I did get a chance to attend a community meeting on the democracy voucher public financing. And I hope all the commissioners follow our social media accounts, but I tweeted and put on Facebook the link to that if anybody wants to see that presentation. There was a new report by MapLight, who's a in that campaign finance reform advocacy. It just issued a new report specifically on trends in Oakland. Really echoes the same results that we found ourselves in our Race to Power report. And then there's also a discussion of, what democracy vouchers have meant in Seattle, and some discussion of how that could be impactful in Oakland. So I'd really encourage people to check out that video.
So that sounds like that might be a nice topic for you to speak about at one of our next meetings, to give us a little bit more detail about what you learned there. That way the community can also hear it in a little bit more detail as well. And then maybe we should add, republicize that on our site, so that the community will know a little bit more about it. Any other comments from the commissioners? If not, we'll open it up for public forum. I see Mr. Kantz, you have 3 minutes.
Hi, good evening again. I'd just like to let you know that the Redistricting Commission has a significant problem with this Form 700s. When I went through them all, it didn't appear anybody had filed an assuming office statement on time. There was one commission member I could not find a filing for. There was another commissioner who claimed they had no income in Oakland, but in fact makes about $200,000 a year working on Broadway in downtown Oakland. So there is a serious problem at the Redistricting Commission with that issue. And beyond that, there's some other things around the Redistricting Commission concerning ethics problems around, like, people who sit on nonprofit boards that make who have large contracts with the city serving on the Redistricting Commission. And that raises some questions around the whole Government Ethics Act. So in terms of the Redistricting Commission, things didn't go quite the way we would have hoped. So that's just something to let you know about. Thank you.
Any other public comment? Hearing none, we will move to our next item on the agenda, the enforcement program, and we will hear a report from Chief Johnson.
I'm sorry to interject. I just wanted to note that I'm going to have to go off video for a number of minutes, but I will be listening and present. I'll be rejoining with video shortly.
Thank you, Commissioner Hill.
Thank you, commissioners. As you can see, the enforcement report is rather a short one. However, even though it's an informational item, I am bringing up for discussion for the commission the single dismissal matter that was included on your informational items in the agenda. I hope you had an opportunity to read through the dismissal letter, both the dismissal letter that went to the respondent and the dismissal letter that went to the complainant in this matter. For those who are assembled in the community and may not have an opportunity to have the physical document in your hand, I did want to provide some context in this dismissal letter, both for the commission and for the community. First, starting with some brief facts with regard to the Redistricting Commission. As most of you may already know, the Redistricting Commission comes along to handle a very important issue for the community every 10 years when there is a design for redistricting maps for important items like voting, community acquiring of certain parks, recreation businesses, federal funding. So the creation of these maps are very contested, important, and serious matter for the city. Unfortunately, because this commission is not a long-standing sitting commission, the Redistricting Commission, new members are brought on, and there is some basic training that is provided for them. However, this year, in addition to the basic training that they did receive, there was a change in long-standing staff. So new staff was hired, long-standing staff individuals stepped away from their duties. With this combined set of circumstances, came this very contested redistricting discussion with the community in the month of December 2021. Add on to it, part of the commission's charge and certain provisions of their charge, they had a deadline of December 31st by which they were supposed to conduct certain matters and finish the selections of the map. Because of that, the commission, as it got closer to that deadline, set 2 to 3 additional special meetings to come together with the community and address the maps that were being proposed in the redistricting for Oakland. One of the special meetings, December 13th of 2021, was set for this discussion of the redistricting maps. Unfortunately, the staff was able to post the notice of the meeting as well as the required attachments to the Office of the Administrator, Clerk's office, the usual physical places where they turn in their agenda and accompanying attachments. Unfortunate for the commission, they did not send the agenda and notice of the December 13th special meeting to its email subscribers.
Oops.
So as the December 13th meeting came to fruition, there were several members of the community who found out from other sources about the meeting, attended the meeting, and shared their concerns about the lack of notice and agenda and attachments that went out via email. Thus, the complaints that were received by the Public Ethics Commission, first starting December 23rd of 2021, that complaint was Mr. Can's complaint and the subject of the dismissal that you have before you. Within about a week of receiving Mr. Can's complaint, we also received 2 additional complaints. The last complaint coming within the middle of January of 2022. The complaints were similar in nature. However, there were some differences. The only complaint that is before you tonight, the matter that we were able to present in preliminary review, is Mr. Can's item. So when we received his formal complaint, it was clear there were essentially 2 allegations that Mr. Can's was making. One is there was a failure to provide notice and agenda-related attachments to the email subscribers. In addition, there was a complaint that because the agenda and agenda-related items, like specifically either maps or additional documentation that included comments that were made by Redistricting Commission members that were not dispersed to the public that were signed up to receive the subscriber emails. So in those 2 complaints, after a very close review of the facts, I would love for this commission to understand we prioritized these complaints for the Redistricting Commission right away because we knew this was a time-sensitive issue. We also understood that there was a series of ongoing meetings that was still going to occur. So we wanted to make sure that we immediately investigate these items, and that is why this matter is before this body tonight. We were able within 5 weeks to do the investigation and bring it back before this commission through several holiday periods from December 23rd all the way through February. So after prioritizing this complaint, what happens after we do our preliminary investigation, our policy is that we call and we talk to every complainant. One, to explain to them what process we are and what we were able to find out in our investigation. We asked if there is additional information or additional complaints that they'd like to make, because if so, that would alter our resolution of what this matter would possibly be. And then the absence of additional evidence or information. And if a decision is made that the matter is to be dismissed, we actually inform the complainant of our reasons there is a dismissal and invite any contrary information or differences of opinions. In this particular case, that was done with Mr. Cans. Mr. Cans was called, discussed the matter with him. Ultimately, Mr. Cans disagreed with my analysis, and thus we are here this evening. What I'd like to point out for the commission and for those watching at home is that we did receive, the enforcement unit did receive Mr. Cans' written statement regarding his evaluation of the conduct that occurred with the Redistricting Commission. We read it carefully and gave it careful consideration. And tonight, I must submit to this commission that it does not change the evaluation and the ultimate resolution of dismissal that staff of the enforcement unit has before this commission tonight. And the reason for that is because the law hasn't changed. In following the law, we are limited. We, as in the Public Ethics Commission, is limited as to what you can do in a particular situation like this. Starting first with the agreed upon fact. Mr. Cans is exactly correct. The Redistricting Commission failed to send out the notice and agenda and attached agenda-related items to the email subscribers. That is a fact. And under OMC 2.20070 of the Oakland Municipal Code, that is a violation of the Sunshine Act. However, the ordinance does not end at that provision. It goes forward in the face of a violation of that provision to provide exemptions for certain government actions, even though the violation may have occurred as described under Section A1 of the ordinance. Specifically, the statute says that notwithstanding a government body's failure to provide an agenda or agenda-related materials to a subscriber list, the failure of that government body to provide that does not invalidate, does not, in fact, the language says shall not invalidate the actions of that government body. Furthermore, the additional subsection goes further to say that if a complainant actually either appeared at the meeting or received actual notice, even if the government body violated subsection A1, it shall not invalidate the actions that government body took at that particular meeting. Following the law in this particular case means, although we agree 100% with Mr. Cans that the Redistricting Commission did not provide the agenda and attachments to its email subscribers, the law provides this exemption for the conduct that occurred. Secondly, the related complaint having to do with the failure to receive the agenda-related items and comments that were written on maps by the Redistricting Commission members. The statute further goes on to say that in this particular case, the Sunshine Act prohibits, it actually prohibits a complainant for filing a complaint with the Public Ethics Commission if there has been a request made to the government bodies. So in this case, when Mr. Cans did not receive the agenda, make a request of the Redistricting Commission to give him a copy of the agenda and the agenda-related items that were not emailed to him. In the event they failed upon that request to provide that information to him, the next step required is to actually go to the Public Ethics Commission mediation program. And for some of our commission members, you are very familiar with our mediation program and what we provide in terms of collecting that information and providing it to a requester who needs those documents. Ultimately, the provisions of this statute, and it is an equal provision to those in the California Brown Act. These provisions, although it lays out the violation, it also provides very clear exemptions for the government body. Lastly, to conclude, neither the Sunshine Ordinance or the Brown Act provides authority for the Public Ethics Commission to force or order the Redistricting Commission to cure and correct. I invite the commission to actually speak directly with the city attorney, Trisha Shaffey, if you have any direct questions on that matter. I know Commissioner Mitchick has brought up a time before asking the very poignant question, do we have the authority to make another commission cure and correct? I think it's important that even after we do the evaluation under the ordinances, as I've laid out for you in both in the written materials and in my statement, that above all, even if this violation occurred, even if the exemptions didn't apply, in which they do, there is no section in either the Sunshine Act or the California Brown Act that gives this commission the authority to order the Redistricting Commission to cure and correct. We can recommend, we can suggest, we can tell them best practices. You have the authority to do an audit if you so chose. However, the decision to cure and correct lies with that body. And again, I invite you to ask specific questions. Certainly if you have them of me, but Tricia Shappy to address these issues of the California statute in particular, if you have questions about what the Brown Act requires in addition to our ordinance. So unfortunately, although this is a highly contested, important matter, I'm certain the commissioners have been following along as this redistricting process has gone along sort of tumultuously. But at the end of the day, these provisions, unfortunately, don't provide the resolution that the complainant is looking for. And I understand his frustration about that. I understand even his desire to have some of these rules changed. But the matter that was before me is the current laws. We evaluated these matters under the laws of Oakland and in conjunction with the Brown Act. And that is why this complaint was dismissed. Thank you. That is my statement, unless you have questions of me.
Yes, Chief Johnson, I had one question. I know we received a response from Mr. Cairns, and if I recall correctly, did it mention the fact that there was a cure and correct meeting with some other body? I thought there was some discussion about a meeting with the city attorney's office.
There was what was mentioned in the letter was that the city council itself made a decision to cure and correct for one of its meetings.
Okay.
That's the example that was given. But to my knowledge, the Redistricting Commission has not, even though we recommended, because if you took a look at my letter that went to the respondent, I strongly recommended that they consider doing a best practice. You might not be required to do it, but maybe the best practice would be admitting that you made a mistake or that there was a problem and providing that transparency to the community. So we certainly made that recommendation. However, to my knowledge, they didn't do an official cure and correct, although the Redistricting Commission did not conclude on December 31st. Most of you may already know this. They continue to have meetings up until February. And in fact, I believe they have a meeting happening tonight.
Okay. Did you get any response to the letter that you sent to that commission?
Correct. I did, because during my investigation, I asked them direct questions, starting with, did you actually send the agenda and attachments to your email served subscribers? Because initially there was some question by the Redistricting Commission as to whether that actually occurred. So I had a list of more than 20, 25 questions for them as to what occurred, why it happened, give me background on the matter. So yes, there were 3 responses that came back to my questions.
Okay, I need to clarify. You sent your dismiss. You sent the letter on February 23rd advising that you were dismissing the complaint. Did they respond to that in any way?
No, not that one. During my investigation for the past 5 weeks, I had been communicating back and forth with the Redistricting Commission staff with a series of questions to assist in my evaluation of the case. But after we made our dismissal, there has been no other communication with me from the Redistricting Commission.
Any other commissioners have any comments or questions for Chief Johnson?
I have a quick question, if I may. Chief Johnson, thank you. That was a very thorough background, and I appreciate it. It certainly helped me. I have just kind of a small question. In terms of the requirement of a mediation before filing a complaint, that is in respect to is that right? How we do a request for agenda materials that were not delivered. There's not a a different way of thinking about this because they should have been provided and they weren't. It's a public records request. It's a type of.
Those are the only provisions, and believe me, we looked. Those are the only provisions that are provided with regard to, at the end of the day, if they don't get these documents, what other way can they get the documents? And the statute only seems to provide by, one, making a request, and two, in the absence of the body responding to the request, then you can do a mediation and have the PEC help you get the documents.
So there's significant kind of delay built in. If you don't get the agenda documents timely, you have to go through quite an administrative process. So, okay, thank you very much. That was all for me.
This is not directed at Ms. Johnson directly, but I'd like to kind of go on the record and say that I think the existing policy here is, I don't think it's too strong, too strongly worded to call it a bit absurd, in that if somebody happens to be made aware of a meeting that was not sent out to the subscriber list, and then they understandably attend, even if it's only partway through, they somehow lose some opportunity to rectify the situation under the current policy. So I would love for our commission to consider this more fully at our upcoming retreat and think through whether we might want to recommend a shift to the existing policy that does not essentially penalize members of the public for attending meetings that they were not made aware of through proper channels, such as email subscriber lists.
I guess I would ask Commissioner Hill, what is the actual harm that the individual has suffered when they were actually able to participate in the meeting and get the information?
It's not, so I don't know that the harm is to them in particular, but what you end up with is a situation where if someone is not made aware of the meeting happening and no one contacts them through private channels to let them know, and they're never made aware of it, they're therefore not going to raise a complaint. It's sort of limiting the body of people who are going to be able to raise a successful complaint about the subscriber list not being contacted or an agenda not getting posted in other channels. You have to become aware that the meeting happened, and also not have been made aware of that in time to be able to participate yourself. It just seems like an odd policy that it shouldn't really matter whether the individual was able to attend or not personally, if they were not made aware of the meeting through direct communication, by the body that was meeting. That seems to be the real problem. We shouldn't penalize someone for happening to be connected to someone else who did know the meeting was happening through some other channel and have an opportunity to participate. Does that make sense?
Yeah, I understand what you're saying, but I think typically rules like this are set up so that the person who doesn't get to participate at all is the person that's truly harmed, not the person that, even though I know the goal is to make it available to everybody so that no one actually suffers from it, but it's a dangerous precedent to just make any and everyone the victim in the situation, that they suffer harm and that you would have to overturn it, even though they got the benefit of attending the meeting and getting the item, hearing what happened and participating in it. So, I think it's open for discussion, and it surely is something that we can think about at our our retreat. It's going to be a pretty packed retreat, so there's a lot.
Clear. to hear about their channel. So I'll rest my case.
Comments.
I'll chime in. So, I think that one of the benefits to the statutory period that you're to post notice of a meeting is not just to have enough time to clear your schedule to attend the meeting. It's also to have a chance to read and process the agenda and perhaps form an opinion and perhaps form a comment to provide or provide some feedback. So I would argue that there is actual harm from receiving an agenda after the meeting because it doesn't provide you with that opportunity to form thoughts and opinions and comments for feedback at that meeting. I also just, Johnson, and thank you for that presentation. That was very clear. What was when you asked them why the agenda wasn't sent out, what did they say?
Well, they didn't really have a definitive answer to that. They believed that it had. And in fact, when it was first raised to the Redistricting Commission at the meeting, there was some colloquy where the assertion was made that it was in fact sent out. So the staff was under the impression that the matter had been handled by someone. And then eventually, and this is the information they shared with me, in making the inquiry, because we asked, can you find out for sure if it actually was sent out? Because otherwise we would do that. We would do our own IT search and try to figure out what happened here. And in asking that question, they came back answering the affirmative that they did confirm that items were not sent out, but there was no information as to why that occurred. We're left with it happened. We don't know how.
So I guess my only additional comment is I would just point out that, once we established that, first of all, Mr. doesn't have standing to lodge this complaint, and once we established that it doesn't even matter if they sent the agenda out to the list, there was still nothing under the statute that we could do. We didn't even technically have to go through that whole investigation because there was no standing and there was no nothing we could do about it anyway. But we did anyway, and I think, and I agree with that because I think that this was something that shouldn't have happened. And so it is frustrating to me that, our hands are tied and we were able to write a letter and say, do training next time in 10 years. But I'd like to, continue to think about how we can have consequence for this, within the powers that we've been granted.
I think we should also really make it clear. It depends on the circumstances of the individual. It's not that no one has standing. It depends on the particular facts of the situation. Someone in a different situation from Mr. Kantz who wasn't able to attend the meeting, had no knowledge of the meeting, was not and did not attend it within that time frame, would have standing, as you brought up. So it might have a different impact on them. So the policy as written, the procedures as written, it does have teeth. It just is very fact dependent. And, I understand the frustration of Mr. Kantz and others that, to your point, Commissioner Mitchell, they want to be able to form the opinions and thoughts and make sure that they are prepared for that meeting. It's not just about the fact that they are aware and they're there. I agree with you. They want to have the time to formulate thoughts in case they do want to speak up on a particular item. But I think standing is an important issue, and it really crosses a number of boundaries when you're dealing with legal precedent and rules, because it has to apply to a certain fact and a certain person in a given circumstance. So just something that we can think of. It's almost impossible to do that. Any other commissioner comment? All right, we will open the floor for public comment at this time. Mr. Kantz, I know you've been waiting patiently, so I will let you go first, and we give you 3 minutes.
There we go. Good evening. First of all, there's a straight up violation. Even if you're going to claim that my appearing at the meeting means I have no standing to bring this, I do have standing. And where I have standing is the agenda related materials were not provided. They weren't posted. The agenda related materials, specifically those comments from the commissioners to the consultant, were not posted along with the agenda. And they would have then therefore been available to members of the public to comment. And, this goes back to the Grenache complaint this commission heard in 2004. It was when I was on the commission, and it dealt specifically with the issue of agenda related materials. And as a result of that, John Russo, the city attorney, brought forward an amendment to the Sunshine Ordinance dealing with agenda related materials. And I know many of the members of this commission are attorneys, and it's very similar to discovery in a trial, where you can't show up in the middle of the trial and start throwing something around that the other side didn't know about before the trial. You have to disclose all that. Well, that's in essence what the agenda related materials are about, is to give the public a full picture of what is going into the decision that's being made. And because the public was denied those materials, that's a violation. And both the Brown Act and the Sunshine Ordinance do not allow that. They have to be available at the same time the agenda is posted. And to get into this thing about mediation, that's a totally separate issue. I did not make a public records request for those materials. They were supposed to be available on the website when the agenda was posted. It's that simple. And I had also raised with staff the additional issue that there were decisions made at the end of that meeting where the public was not allowed to comment. And that issue hasn't been dealt with. And I'm afraid this is all being very politicized, because the city attorney here has a huge conflict of interest, because they've been in court on this issue. They've been representing the Redistricting Commission on this issue. And I raised this issue at the meeting on December 13th. I wrote the staff for the commission the next day, and I got no response until sometime in January. They didn't hold another meeting till December 30th. They had adequate time to hold another meeting and do a cure and correct and clean this up, and they chose not to. And the city attorney was part of that decision. And that's why you need independent legal advice on this issue. Thank you.
Thank you, Mr. Kantz. Next, we have Ms. Knighton Smith. You have 3 minutes. I'm sorry, hold on.
I'm Zinni Abraham. Actually, I'm not her. Thank you very much.
Okay, I'm calling Ms. Knighton Smith. I'll allow her to talk. Go ahead, Ms. Knighton Smith.
Hello?
Yes.
Can
Can you hear me?
Yes.
I'll be really brief. I listened to Mr. Kant. I listened to the discussion of the commissioners. And my concern is that if this was a problem and it wasn't corrected, doesn't that negate everything that followed? That the actions and the discussions and that the Redistricting Commission took was in violation of everything. So them selecting the map and doing the remainder of the task, which didn't meet the deadline for December 31st, as well as continue this and adopting a map is invalidated. And my concern is it's like in that last meeting that I attended in January where they disenfranchised District 7 for District 6, where they moved they said they had to make District 6 economically viable, and therefore they had to put the Coliseum in the neighboring close community, the Coliseum neighborhood, into District 6. But they took everything away from District 7. They also took away a solid voting block in Tola Heights and Grass Valley and Glenwood, and put all of that in District 6. And so now District 7 doesn't have a strong, balanced black voting block. They have been, disenfranchised by taking their economic engine that they worked on for the past 20 years and given to District 6. And also the one person that's on the commission worked on Mr. Lauren Taylor's campaign. So like it started with that December 13th meeting, and they are in violation of everything. And that the committee is supposed to be looking at all of that, including the concerns that they did an improper meeting. Thank you.
Thank you, ma'am. All right, Mr. Abraham.
Thank you very much. Oh, I'm muted now. Oh, you're going to unmute. Okay, hold on a second. All right, now we're unmuted. Thank you very much. This is a very alarming development. And, ironically, I just talked to John Russo. That we talk all the time, not about this. But there was a time in our history when if this had gone down, it would have been treated so that the ultimate deliberative body in the city would have had to deal with it in some case, or even if it was for discussion, and that's the city council. I find it a little alarming that it seems like the Ethics Commission isn't going to do that. I think it's a good idea to reverse course and do that rather than kind of, give up the idea that you're going to twiddle your thumbs and say, oh, gee, what can we do? What should we do? Oh, my Lord. This is a democracy. You can bring it to the city council. You can have it agendized for discussion, at least, and let them deal with it appropriately. But to stop at this point, given how ugly this looks, is just not a good idea. Think outside the box in terms of how to solve the problem rather than thinking in the box. This is a serious issue, and we can't go backward on this sort of thing. So I would really encourage you to send this to the council and let them deal with it and make it public that you're going to do so. Thank you.
Thank you, Mr. Abraham. Any additional comments from the public? Okay, is there any additional comments from the commissioners before we move on to item number 11?
I'll just ask Chief Johnson, the two additional things that Mr. Kantz brought up, the claim that that there were agenda items that should have been posted that were not posted even to the website. and also the claim about the vote being taken without public comment. Were those things that were included in the initial complaint and that you looked at?
They were not.
Okay.
I will say, without being able to give any direct discussions of matters that are still under investigation, there were 2 separate complaints, one of which does raise those issues, but they are currently still under investigation.
Any other comments from the commissioners? Okay, we will move on to item number 11, the Executive Director's Report. Director Barzotto.
Thank you. I have just one thing to add to the report. I've been speaking with the BayPEC Coalition, and they are interested in bringing to the Commission a proposed ballot measure regarding campaign financing and a kind of a redesign pursuant to a lot of the discussions we've had over these past several years. So this means in April, it's possible they could have it by the April meeting, and that's April 13th. And I know we had talked about canceling that meeting because we have our retreat scheduled for the 21st and 22nd. But I'm asking if you could all please keep your calendars open, and that meeting is still scheduled at this point. And the reason would be mostly because we want to be able to hear that proposed bill language. It's possible it could happen in May instead, but April looks to be the more ideal date. So my apologies. I know that means we'll probably have 3 meetings in April. But if we did do that, my thought would be that we would mainly hear just that legislation. It's going to take some time to work through it. And so if we do have that April 13th meeting, then that would be my goal is kind of keep it simple. Although I'm looking at Kelly and I'm thinking, well, it does depend on if we have a settlement to bring as well. So anyway, no promises, but let's leave that on the agenda if we could. And that's my only update to the written report. Thank you.
Any questions from the commissioners? Director Barzotto, do you have any updates from where we are on an additional commissioner for the commission?
My understanding was that there would be folks observing the meeting tonight, and that there are some final applicants that are being considered. And so that's all I know. That there has to be the folks who are being considered have to be able to observe a meeting first. So I'm hopeful that we'll hear in the next couple of days or next week, and that's all I know from the auditor's office at this point.
Okay, thank you. And yeah, thank you for correcting me. It's city auditor's office. I said city manager earlier, but it is city auditor's office. With that being said, is there any public comment on the executive director's report? Hearing none, we move to future meeting business. Item number 12 are there any future meeting items for the commission other than the fact that hopefully everybody has their calendar clear for our retreat on the 21st and the 22nd, and to make sure that the public does know that that information, the time and the date, I believe will be shared with the public. Is that correct? So if there's anyone who wants to attend and watch and listen during our retreat, you may do so, and that information will be shared with the public. Commissioner Tooman.
Just as a matter of specifics, is this retreat intended to be something that we're sort of independently checking in with via Zoom, or are we actually going to spend some time with one another face to face? I would, given the governor's position on the virus, I would certainly love to see us all in one room together. I always feel kind of distant with Zoom, and I had to teach for 2 years using Zoom, and it kind of gets us through the process. I didn't feel like my students learned as much as they would in a face-to-face situation. And if the purpose of this retreat is for us to dig in on things and have back and forth discussion and the like. I would find that so much more of a pleasant experience being with my colleagues than staring and talking to a screen. And so I'm just putting that out there to see if there are any other people who might feel the same way.
I totally agree with you. That was one of the things I was going to talk to Director Barazotto about is, with the changes in the environment, are we open to having this 2-day retreat in person? And you would also have to figure out where that would take place. So I think that's another issue that she'd have to deal with. But I'd love to hear comments from others and Director Barazotto on her thoughts.
I will say I love the idea, and I am unlikely to be able to get away for a full 2 evenings from a 5-month-old, but especially with lack of vaccine access or availability for the little ones right now. But perhaps a hybrid option, or I could attend it partially, but probably not both nights for that full time in person.
Other thoughts, concerns from commissioners?
I would be open to in-person. Either way works for me.
Yep, either way works for me.
Director Barazotto, your thoughts?
I think it would be fabulous for us to meet in person. I think for some of us, it'll be the first time we have ever met. So in person. And we're going to be soliciting 3 proposals, but the first consultant I've spoken with can do either way. And of course, their preference is in person as well. So I don't think it'll be a challenge finding a room. We just want to make sure that we're following all the rules and protocols for entering a city building. But we'll handle all of that and we'll keep you posted. And certainly we'll try to do in person as much as possible. And thank you, Commissioner Hill, for mentioning. And we'll also certainly look at an option for a hybrid, possibly have you teleconference in. There may be some changes happening to state law between now and then, but it's all still a little bit up in the air as to what's required when we have a commissioner call in that type of situation. But we'll keep you posted, and we'll certainly try our best to make sure that everyone's needs are met.
All right. Any additional commissioner comment? Mr. Cans, 2 minutes.
I would just ask that, are you hearing me?
Yes.
Okay. My only comment would be, personally, I would not attend a meeting right now. I have a wife who's immunocompromised, immunosuppressed. And given the variants that are going around, everything that's going on, I can't risk being in a closed room with people because I can't bring it home. My wife would literally die if she got it. So I would ask, if you have an in-person meeting, at least provide the Zoom alternative for the public or for members of the commission, maybe that aren't comfortable to be there, so that it'd be done both ways. And I think that some of this is going to be coming up in the future for people, because I think the ADA will speak out on this at some point. For people who are immunocompromised, this is a really big issue, and you need to provide for those people. Thank you.
Thank you. Any other public comment? All right. With that being said, I believe we are at the end of our agenda. Thank you all for a very efficient meeting. Thank you, staff, for the work that you've done and presented tonight. And appreciate all the commissioner comments as well. And thank you for the public for attending. It's always nice to see our numbers go up on the people that are attending our meetings. We hope that can grow as we go in person or in hybrid. So we look forward to making sure that the citizens of Oakland feel like they're heard through this process and have a voice in this process. So we thank you.
Thank you, Evan.
Good night, everybody.
Good night.
Thank you. Good night.
Good night.
Good night.
Well, folks, that was fun. I don't know if that was a lot of fun. So let me explain to you before I sign off what you missed. My fault. So when I first activated this, the one thing that I forgot to do was press the go live button. And so you missed for me, it was the number one marquee consideration. That was the city council pay raise. Mr. Can spoke, I spoke, and I have to credit the Public Ethics Commission for actually listening to what we had to say. And collectively, what we were saying is, I said that there should be performance standards, and Joe Tuman echoed that, as did the commission chair and others. And Ralph Kant said that he didn't feel that the Ethics Commission was the place where the matter of the city council salary should be agendized at all. He felt it should be another body. But with all that, as Whitney Barrasso correctly points out, she's the executive director of the commission. The charter says, hey, basically, you have to agree to this increase and elevate it. And, let's face it, given who appoints the people to sit on the Ethics Commission, they're not independent. They're not voted in by the public. It's highly unlikely you're going to get commissioners to vote against the pay raise of the people that put them in those chairs, right? But there should be a performance standard attached given circumstances like the pandemic and what government hasn't done, which has created, among other things, a gigantic increase in homelessness, numbers of closures of businesses. Yeah, I felt that matter of an increase should not have gone down without a discussion. There was a brief discussion on the need for performance standard. Fortunately, however, I did realize my mistake, and I activated the live stream, as you can see, because you're here, for you to get that other issue regarding what was originally an email sent to me, which basically said that the staff is dismissing a complaint concerning the Redistricting Commission's failure to properly notice its December 13th, 2021 meeting. The agenda was never sent to agenda subscribers, which is a violation of the Oakland Sunshine Ordinance and the State Brown Act. And that, and basically you heard the response of the Ethics Commission and the city attorney basically saying, well, the person that lodged the complaint had no standing to lodge the complaint. But that doesn't escape the fact that what was done was wrong. And so that's why this matter should be advanced to the city council. It's not a good thing. So other than that, there were other decisions that were made, not decisions, but information that was imparted in the onset, basically approval of the minutes from the previous meeting. So you didn't miss anything from what I forgot to record, except what I just told you regarding the city council pay raise. With that, live long and prosper. And that ends this broadcast. Thank you for attending and watching. And subscribe to Zenny62 on YouTube and bookmark oaklandnewsnowblog.com. And check out oaklandnewsonline.com too. And check out oaklandfocus.blogspot.com. I have a lot of blogs focused on Oakland. See ya.